Smith versus Ergo Solutions, LLC. This is a sexual harassment case. The company did not have insurance to cover them, and they retained my office. And there were actually multiple cases. At one point, there was a class action which I had gotten dismissed, totally bogus. And this case, another case, went to jury trial a year ago. I did win that case in January. That was a retaliation case. But this case had a potential for a large verdict because the trial fell out during the week in which there were additional Brett Kavanaugh allegations. The case was in federal court, Washington, D.C., a lot of emotions running high. Also, a very friendly plaintiff's trial judge, Judge John Bates. Definitely, he's a plaintiff's guy. I know that because most of my practice is plaintiff's work, as all of you know. And I've been before John Bates a number of times. And so I would say what made this case difficult is just the atmosphere. And if you think of the parallel in sports, this is kind of a road game, playoff situation, no insurance. If the plaintiff scores a point on this case, wins $1, the company has to pay all the attorney fees of the plaintiff's lawyers. So you have to pitch a shutout here. You have to win, and you have to win big. And that is exactly what we did. And this was a tough case. There was a lot of potentially damaging evidence against the company. There were salacious pictures sent by the CEO, a report in her office within the company that could have been interpreted, I should say, that the CEO had committed sexual harassment. Turned out that was not the case, but it could have been read that way. And the replacement human resources person hired in 2010, this conduct allegedly happened between the years of 2005 and 2010. So the new HR person testified that the old company's sexual harassment policy was confusing to him and had to be rewritten. So how do you win a case like this representing the defendant in this type of error? Well, jury selection. You have to take that very seriously as a lawyer, no matter what side you're on. And you have to understand what the climate is. And it's a believe all women climate right here in D.C. Sexual harassment. So you have to get out the oversympathetic people. And it worked. There were about 3 to 4 jurors who admitted on some voir dire questions, some that I had followed up on, that they couldn't be fair. That just due to the situation, what was going on in Washington with all the claims of sexual harassment, they would be overly sympathetic to the plaintiff. They were dismissed for cause. I did not have to use any of my preemptory challenges. That was a big moment in the trial. Then there were some other jurors, men and women, who I asked about the Believe All Women phantom statute. And they agreed that had no place in an actual court of law. So we did get a sympathetic jury, or less sympathetic for the plaintiff, I should say, and people, many of them older, who were going to apply the law. So the trial starts. And I followed my own advice on what I tell my clients who are plaintiffs. The most important part of the trial is what? The cross-examination of the plaintiff. That's when the whole thing can unravel, and it did for this plaintiff. The jury has to like and believe the plaintiff. If not, no matter what anybody else has done on the other side, they ain't asking for money. So we attacked the plaintiff on these basic points. First, she contradicted herself as to whether she complained about the harassment. She told the EEOC she didn't complain about the harassment, but she said later in the case that she did. She never complained to anyone in her personal life. And that was a killer that I brought out on closing argument. Meaning, even if you believe that she was scared to complain, she didn't want to complain, the complaints were useless, the jury has to see that as a plaintiff, you would have complained to somebody. Your mother, a relative, a friend, a doctor, a diary. She had none of that. And that was a killer for the plaintiff. She never looked for a job throughout the 5 years she claimed to be harassed. If you are claiming any sort of harassment, you must be looking for another job. Otherwise, the jury believes it really wasn't that serious. And I tell this to people all the time. She had very little corroborating evidence. She had a lifestyle that was completely incompatible with victimhood. These were real problems in the case. One of her star witnesses claimed she was also harassed in 2009, but didn't read an investigation report where she claimed to be phone friends with the alleged harasser, and the two sexted each other pictures before the company hired her. Whoa, that was the biggest blow to the plaintiff in the case. It undermined their whole theory of unwelcome harassment. The report also stated she had sex with the CEO, and even though he denied it, according to her, she enjoyed the sex. That was a big fumble. We did a lot of damage at her deposition, and that's what happens when you're not prepared for your deposition. And if you're a plaintiff, you have to watch the podcasts on deposition. You have to follow the advice. If you don't, you will lose, as happened in this case. And whoa, that was a close call, but we were able to win.